The Committee on Government and Higher Education will come to order. Madam Secretary, if you can please note the roll. Just wanted to thank everyone for being here today. This is just a special information meeting. We're not going to have any actual actions from today's meeting. And I really appreciate there's a number of stakeholders that are here today that have spent some time both to be here and to be part of this and prepared some information for us today. Hey, good morning. So with this, I did have a quick kind of a message I wanted to read with regard to pending litigation. I'm aware of at least one active lawsuit challenging the constitutionality of certain Arizona civil forfeiture laws. The committee will not entertain any statements or comments on pending litigation. Please confine your statements to the subject of Arizona forfeiture law and policy and refrain from discussing the allegations or proceedings in any pending lawsuit. Violation of this advisory may, in my discretion, terminate your opportunity to speak or participate further in this meeting. So if you could be aware of that, try not to bias anything that might currently be going on out in our legal world. Certainly, mentions could probably be made of things that are already out in the public domain, but we'd rather not focus on those in particular, just for for the simple reason that I certainly don't want to harm a prosecutor or a defendant's ability to get a fair trial. So with that said, I'm just going to make just a very, very quick opening statement, and then we're going to get on to our stakeholders that are here today. I'm concerned about civil asset forfeiture more on a national level. I don't know how large the problem is here in Arizona. My concerns primarily are with people that don't fit the RICO definition, people who are not racketeers, who are not drug cartel members, things like that. Those are the ones that if they get caught up in civil asset forfeiture, I'm concerned about that. I'm concerned that their property is typically looked upon as guilty until proven innocent. That the tenets of what we think of the justice system are kind of turned on their head with using civil asset forfeiture. I'm also concerned about the reporting. I feel that we can do a much better job here in Arizona with detailed reporting. That right now it's more of an aggregate reporting. So those are kind of my two main concerns with civil asset forfeiture. Some of the things that I was trying to address in some legislation earlier this year. And with that said, I have a number of individuals who will be speaking this morning. To begin with is Paul Avalar from the Institute of Justice. If you can come forward and just each person that comes forward, if you can just identify yourself for the record. Thank you.
Thank you, Mr. Chairman. My name is Paul Avalar. I'm a senior attorney with the Institute for Justice. Thank you for having this hearing today so that we can talk about what it may be the most important property rights issue in the country, and also an issue that impacts greatly due process rights. There is a national sort of consensus building, bipartisan, that there is something very wrong in the civil forfeiture world today. And amazingly, groups across the political spectrum, as you'll hear from today, have come together to say not only that something is amiss in the law, but also what reforms are needed. And when such strange bedfellows can agree on that, well, I think lawmakers should pay close attention. Mr. Chairman, you've already talked about the upside-down world of civil forfeiture and how it differs so much from what we think of as criminal law. Today I'd like to talk about four primary issues with civil forfeiture. One, protections for innocent owners. Two, the profit incentive. Three, separation of powers. And four, reporting requirements. I'd like to take a moment to clarify, however, what we are not talking about today. We're not talking about actual contraband, things that it is illegal to possess, things like drugs or stolen goods. No one has an interest in true contraband, a property interest in true contraband. It's illegal to own, and therefore the government can't take that from you. Instead, when we're talking about forfeiture today, we are talking about government taking normal, everyday things that normal, everyday people own and have a right to own, things like homes or cars or money. Civil forfeiture is mostly not even a lawsuit against a person. Rather, forfeiture is mostly based on a legal fiction, a lawsuit against an inanimate object. That is why forfeiture cases have unusual names like State of Arizona versus Property, Business, and Building located at 2120 South 4th Avenue, or Arizona v. 1986 Chevy Corvette, or State of Arizona versus $19,000 in U.S. currency. And the same is true at the federal level, where you get even more ridiculous case names like United States versus an article consisting of 50,000 cardboard boxes, more or less, each containing one pair of clacker balls. Unusual to say the least. So what property is forfeitable in Arizona? Well, the favorite lawyer answer, it's complicated and it depends. ARS 134304 provides that all property, including all interests in such property described in a statute providing for its forfeiture, is subject to forfeiture. So you then have to go look at various statutes across the whole of the revised statutes to determine whether any particular property is subject to forfeiture. This is not just the criminal statutes. For example, certain DUI offenses can result in forfeiture of cars, forfeiture of unregistered stills, things like that. So there are a lot of places you have to go look to find out whether your property can be taken. My impression is that in Arizona, most forfeiture is based on the so-called racketeering statutes. And among other things, those statutes provide for forfeiture of all proceeds traceable to an offense, included in the definition of racketeering, all monies and other property used or intended to be used in any manner or part to facilitate the commission of the offense. Now, racketeering in Arizona includes some 33 separate crimes, which therefore give rise to forfeiture. So in Arizona, if a police officer pulls you over for a traffic offense, finds money, and has some suspicion that that money is traceable, a frighteningly low standard to, say, a drug crime, the officer can immediately seize your money, and you are now stuck in Arizona's forfeiture process. I'd like to start with talking about innocent owners in Arizona forfeiture. Mr. Montgomery, Bill Montgomery, the Maricopa County attorney, wrote in the Arizona Republic in December, quote, "Forfeiture is designed as a civil action precisely because it targets illegal activity which a criminal conviction would either be impossible or ineffective in stopping criminal conduct," unquote. One category, I hope, in which a criminal conviction would be impossible to obtain is when the accused is innocent. Mr. Montgomery's statement is an admission that forfeiture happens even in the absence of a criminal conviction. Indeed, forfeiture can happen in Arizona even in the absence of any crime being charged, or even if there is an acquittal in a criminal case. Arizona law expressly provides that claimants, property owners, have the burden to prove their own innocence in a forfeiture case. And so based on the plain language of the statutes and practice under Arizona's forfeiture statutes, it's clear that property owners in Arizona can have their property taken from them forever if no one, much less themselves, has ever been charged with a crime, no one, much less themselves, has ever been convicted of a crime, they cannot prove their own innocence of the alleged criminal activity, or the alleged perpetrator of criminal conduct has been acquitted. So I'd like to pause here and just reiterate that in Arizona, the government need never prove to any degree that a property owner has committed a crime in order to take that owner's home, car, life savings, or nearly any other property. This is by design. As described by Cameron Holmes, a former assistant Arizona Attorney General and the author of Arizona's current forfeiture laws, forfeiture is not about crime. It is an effort to promote social justice through judicial intervention in antisocial behavior. That's a direct quote. The economic nature of this forfeiture is apparent given the enormous differences between civil forfeiture and criminal forfeiture. Quote, "Most obvious, the property is the defendant. No person is accused of any wrongdoing and none need appear. No process issues to compel anyone attendance, and a potential claimant has the option of simply not filing a claim. Thus, no criminal arrest or other record is created." And if I may interject here for a moment, while no record is created, a person can lose his or her home, car, life savings in a situation where, as Mr. Montgomery admits, a criminal conviction would be impossible to obtain. Returning to Mr. Holmes, there's no element of proof of the guilt of any person, and therefore no stigmatization. No stigma attaches to being a claimant in forfeiture cases because all sorts of property owners and interest owners become claimants, including financial institutions and others of unquestioned reputation. The forfeiture is strict liability. It divests some property interests without regard to personal fault. While it is true that legislative concern for commerce in this commercially oriented remedy led to the exemption of categories of interests exempt from forfeiture, these exemptions are not based on innocence. They are based instead on commercial considerations. Courts in Arizona have very little authority, in fact, no authority, to mitigate a forfeiture in Arizona. The role of the court is fundamentally different in forfeiture than in criminal litigation. If forfeiture happens and the owner can't prove his or her innocence, the court has no discretion but to declare forfeiture. Again, this is straight from Mr. Holmes. It performs no proportionality testing, does not examine the life, personality, or propensity for antisocial behavior of any claimant. Were this not concerning enough, Arizona law further magnifies the threat of civil forfeiture to innocent owners. First, there's no provision for indigent representation in forfeiture actions. Because forfeiture is a civil proceeding, there's no right to have an attorney provided to you, no public defender for forfeiture. If you cannot afford an attorney, you are out of luck. This means that government can take property from people, including, again, their homes and cars, but these people never have a lawyer's assistance. Second, Arizona law prohibits awards of attorney's fees to innocent owners who successfully challenge forfeiture. Unique in all the country, Arizona law awards the government 100% of its attorney's fees and costs in any case in which a claimant is not 100% successful in getting their property back. These provisions obviously hinder people's ability to retain a lawyer and further discourage them from even innocent owners from trying to protect the property rights. Indeed, as Mr. Jacobu will talk about later, law enforcement uses their right to fees to threaten innocent owners against even trying to reclaim their property in court. So if you are an innocent owner, fighting back may not be worth it. It will cost you thousands of dollars for an attorney and maybe even more than what is at stake in the forfeiture itself. The deck is stacked against you in the proceedings, and if you are less than 100% successful, you are on the hook for yet more thousands in fees. It should be no surprise then that many people choose, quite rationally, just to give up rather than to protect their rights in court. Exacerbating the problems of civil forfeiture is the profit incentive, what we call policing for profit. In Arizona, law enforcement gets to keep up to 100% of what they take through forfeiture. No surprise then that when IJ looked at state laws governing forfeiture nationwide, Arizona scored a D-. Pairing very minimal protections for property owners with profit incentive for law enforcement means that civil forfeiture is a threat to both due process and property rights. And the profit incentive is very important to understand. It's bad for law enforcement and bad for the public. It greatly warps law enforcement priorities. And it leads, I think what would be of primary concern to this legislature, to executive branch agencies that are immune from legislative oversight because they become self-funding. As the Arizona Prosecuting Attorneys Advisory Council itself has stated, quote, an asset forfeiture practice that supplements other law enforcement activities provides an opportunity that is unique among governmental agencies, the direct augmentation of the agency's budget through the performance of its designated function. In short, in Arizona, law enforcement can beef up their budgets, free from legislative oversight, by taking people's stuff through forfeiture. And Arizona law enforcement has taken more than $500 million through civil forfeiture in the last 15 years. These charts here show this is forfeiture through the state program. These charts are also in the packet that's been handed to you and are also reproduced. This one is reproduced in the booklet. So as you can see in Arizona, since fiscal year 2000 through 2014, the state had taken nearly $412 million through civil forfeiture, the state program. In 2015, fiscal year 2015, we know they took more than $40 million through that process. In addition, there's also federal equitable sharing, and as you can see from year 2000 to 2013, they took nearly $93 million through this federal program here. So when you add all that up, it's more than $500 million. That's $500 million that has never been appropriated by the legislature, that is largely free, again, from oversight.
Paul, you'll have to try to wrap up just so we have enough time to get through our list of speakers.
Sure thing.
Very good. Thank you.
One thing to note is that the financial incentive is so compelling that it leads, I think, a lot of times law enforcement to do things that aren't about law enforcement. For example, the issue of roadside waivers. And there's an example of a roadside waiver in Arizona, again, in your packet. They are used. This one was presented to a driver who was stopped, searched. No drugs were found in his car, but $8,400 was. The driver was presented with a disclaimer that basically told him, look, just say this money isn't yours, and you'll never hear from us again. Now, if this guy is really involved in criminal activity, that is not something that law enforcement ought to be doing. They shouldn't just be taking his money. They should be trying to investigate crimes, but that's not what's happening. To be blunt, that's not law enforcement. It's literally highway robbery, and it happens because of the profit incentive. Now, there are many things about forfeiture that we don't know, and we'll be talking about those later, including how many forfeitures are happening, in what circumstances, the size of these forfeitures. All of these things are unknown because of Arizona's very lax reporting laws. Where we know about things in the aggregate, we know how much money is at stake. But we don't know where that money came from, and in many instances, we don't know where it's going. And we have some folks here to talk about that issue as well. Thank you so much for your time and attention. This is a very important issue. We could talk about this for literally days, I think. But if the committee has any questions, I'm happy to entertain them. Otherwise, I'm happy to have lots of other very knowledgeable people talk about what they know.
Thank you, Paul. I think we're going to focus primarily on getting through all of our presentations, and then at the end, if we have any time, which I'm not sure we will, but we'll entertain some questions then.
Thank you.
Very good. Thank you. Next, Jared Blanchard. If you could identify yourself for the record.
Good morning. I'm Jared Blanchard. I'm a staff attorney with the Goldwater Institute. As Paul said, we don't know many times how the money is being used after it goes in these instances. And as he mentioned, law enforcement many times gets to keep 100% of the funds they seize. So my talk is focused on the Goldwater Institute's concerns with how that money is being spent once it enters the law enforcement coffers. Now, as you know, the Goldwater Institute is very concerned with public money being spent pursuant to the Arizona Constitution. Specifically, I want to focus on the gift clause of the Arizona Constitution, which pretty much says that if public money is going to be spent, the public has to get something of equal value in return. Unfortunately, we don't have much information about how law enforcement is spending this money, which does become public money once they've seized it. And from what's been going on, it looks like many instances it is not being used in accordance with the Arizona Constitution and Arizona law. Anytime you see a photograph of a law enforcement official handing a check to something like a softball team or some other organization where it's not really clear what the public's getting in return, if there's a contract associated with it to ensure that that public money that's being handed out is actually getting the public something back, those questions all need to be raised. And unfortunately, as it stands right now, this is a very opaque situation. The Goldwater Institute has sent out public records requests to several different law enforcement organizations across the state because we are very concerned that this money is essentially being used as monopoly money, just free money that law enforcement officials can use to their own ends. And public money needs to be used and abided by for the public trust. Anytime you see something that says money or this was paid for with money seized from criminals or some sort of tagline like that, I would hope that you ask the question, is this an appropriate use of public money? Is this being used according to Arizona law? Is this abiding by the Arizona Constitution? And right now, because of how opaque the system is, many times we can't say for sure. I'm hoping this comes to light more in the future, but moving forward, I would strongly encourage any civil asset forfeiture reform that happens also come with strict transparency measures to ensure that the public knows how this money is being spent after it's taken. It's very important that this isn't just a private slush fund that is used to either bolster someone's political career or to just make someone feel good because they're be able to spend money and help people in a way that doesn't benefit the public but makes them look good or feel good. And with that, I'm happy to answer any questions that you have.
Well, thank you very much. I appreciate it.
Thank you.
Let's see. Next person will be Kathy Brody.
Good morning, Mr. Chairman and members. Thank you again for having us here. My name is Kathy Brody. I am a lawyer in private practice here in Phoenix. I'm a partner at the law firm of Osborne Maladon, and I'm also the immediate past president and co-chair of the Legislative and Policy Committee for the Arizona Attorneys for Criminal Justice. We are a statewide membership organization of criminal defense lawyers that come from private practice like myself and also the indigent defense agencies around the state. You're going to hear statistics and stories and facts. And so I thought from my perspective, it might be helpful for you to hear how this is experienced from defense attorneys who represent people who are both charged with crimes and also get their property taken by the government. I became a lawyer, and I know a lot of my criminal defense colleagues became a lawyer probably for some of the same reasons that you all are doing what you're doing. We care about our communities, we care about our country, we care about the Constitution, and we want to help people and we want to make a difference. And so when we're doing the work that we're doing, that's why we do it. We want to help people. And I've gravitated toward criminal defense because I've found that when the government is involved in litigation or investigation, that is often when people need help the most because the government is so, in all of its iterations, can be so powerful. And people who are under government inquiry or subject to government conduct really need help. I've represented people who have almost no money at all. I've represented politicians. I've represented CEOs with all the money in the world. I've represented Fortune 500 companies and small mom and pop companies. And I can tell you, when the government is on the other side of any of those people, it is scary, and they need help from lawyers. It's going to affect whether it goes anywhere. It's going to affect their reputation. It's going to affect their mental health. It's going to affect whether their friends want to even talk to them. And, you know, many times the government gets it right. I live here. I don't want crime in my neighborhood. I want to be protected. I want my family to be safe. But unfortunately, many times the government is not right. And the government sometimes is not right because the people at the helm are politically motivated. Sometimes they're personally motivated to go after the people or the causes that they're going after. And sometimes the government is just so blinded in their zeal to try to do the right thing that they are not really paying attention to what the facts are and what is going on. And so, you know, fortunately, when people come to me and they're scared, I can tell them, look, hey, yes, the government is going after you, but there are protections for you that will, you know, stop you from going to jail, hopefully stop you from having to pay money if you indeed didn't do what you're accused of doing. You know, I tell them, look, we are going to know what you're accused of. The government is going to tell us what they think you did wrong. The government, if they want to put you in jail or they want to take your money, usually in the criminal process, they have to prove that you committed that crime beyond the reasonable doubt. That is the government's burden to prove that you did something wrong. When you're fighting a criminal or other government inquiry, usually you can fight it. You can fight it tooth and nail if you want to, and you know, and you don't have any repercussions for fighting. In other words, if you lose, you're just subject to that penalty that was there for the crime. You know, you're going to go away. And I mean, you know, from my perspective, probably not surprisingly, I find it one of the protections very important that a person is entitled to a lawyer when they are accused of a crime. And if you have money, you can hire somebody like me at a private law firm to fight for you. And if you don't have money, you're constitutionally entitled to a lawyer for you know, one of my many capable colleagues that works at the indigent defense agencies all around this state. You can get a lawyer and fight. that, as Paul mentioned earlier, is absolutely turned on its head in forfeiture proceedings. The author of these forfeiture laws designed them to stack the decks in favor of the government and against criminal defendants, and that's exactly what they do. They don't have to accuse you of a crime or tell you what they think you did wrong. They don't have to. They don't have to prove beyond a reasonable doubt that there was any crime committed at all. The burden is much, much less. And you don't have to, and you don't get a lawyer. You're not entitled to a lawyer, and many, many people can't even afford to pay a lawyer depending on the amounts of money that are at issue. I hear from criminal defense lawyers all around the state. I ask them, please tell me your stories of what you're seeing out there. And I just got an email this morning from a defense lawyer in private practice in Yavapai County. And this is very short, and I thought it really well illustrates some of the problems that we're seeing out there. So I thought I would read that to you quickly before I conclude. And this is from, his name is David Shapiro. He's a lawyer in Yavapai County. He says, there are many cases in Yavapai County where law enforcement and the county attorney's office will forfeit quantities of cash in any amount. Though no evidence of crime exists, the owners of the cash will be arrested and charged with money laundering and the cash forfeited. The charges will be dropped, and the victims will have to go through, the people whose money got taken, will have to go through a terribly skewed process in which they will have a short amount of time to find a lawyer, contest the forfeiture, and then return to Arizona to prove that the money was not a proceed of a crime. Many of these people are stopped on I-40, the route to Las Vegas, from and to which people often are carrying fairly large sums of cash. There's a pending case in Yavapai County, he says, in which a car of 3 African Americans was stopped with over $100,000 in cash. One was headed to California to purchase a tractor trailer. The other 2 were drivers to bring the rig back east from where they started. All were charged with money laundering, just for having $100,000 in cash. That's a good example. He says, I've also had clients lose $1,000 to $6,000 when they didn't have proof of where they got the money, after they saved it doing cash work, cleaning houses, being handymans, etc. Some were charged with crimes and convicted, yet the money was not tied to the crime. It is nearly impossible to find an attorney to fight a forfeiture when the amounts are below $10,000. And that, I think, illustrates the problem that I see and my colleagues see in the criminal defense community. We want to help people. We know that the government is not always right, and that people are losing their cars. They're losing the money in their payroll accounts to pay their employees. They're losing their houses. They're losing their life savings, even when no crime has been committed and they've never even been accused of the crime. And it's hard for us, from our perspective, to help these people. We can't help them because they don't have enough money to hire us, or they're not entitled to the indigent defense services. So thank you again, Mr. Chairman.
Thank you very much. Appreciate that. Let me pull up our next person. Miriam Gutierrez. Is Miriam here, or somebody from Maricopa here to speak this morning? I guess not. Okay. Had a really good discussion with Miriam not too long ago. Kim McInerney. Is Kim here? Okay. Kim is from the Arizona Prosecutors Council. Jay Caboo. Is Jay here?
Good morning, Mr. Chairman, members of the committee. I'm Jay Caboo. I am a lawyer here in Phoenix in private practice. I'm a partner at the law firm of Perkins Coie, and I am also lead counsel for the plaintiff in the Cox versus Voiles litigation, which is one of the forfeiture cases that's pending right now, which challenges the constitutionality of certain Arizona forfeiture statutes. I've been litigating on the defense side forfeiture cases in Arizona for over a decade, and wins in those cases are very few and very far between. Most of my clients haven't been charged with crimes. And almost all of them lost some or all of the money that was taken from them. And my colleagues have ably touched on a number of the reasons why that's true, but I want to do a little bit of extension on what they've said, and then I would really invite questions from the committee. I want to start, though, by saying it's unfortunate that law enforcement isn't here. This process of reforming forfeiture laws should not be and isn't anti-law enforcement. It's not anti-police or anti-prosecutors. As Ms. Brody touched on earlier, a great number of us here live in Arizona. There's only a few of us who don't. A great number of us have families with small children that we count on law enforcement to protect, and we appreciate their service. That doesn't mean that they should be appropriators of $500 million. It doesn't mean that they are infallible. And the fact that we have had such a hard time engaging in a productive discussion on an issue where there is such bipartisan support is unfortunate, and it is a source of great dismay to every single person in this coalition. We have groups here that are as diverse as the American Civil Liberties Union, the Goldwater Institute, and as Paul said earlier, these are somewhat strange bedfellows. But in an era, especially in this election year, where there is so much disagreement amongst these traditional adversaries, our only adversary is law enforcement. Why is that? It's the money. They want the money. And they don't want to talk about losing it. And that's really unfortunate because they're not always right. Paul alluded earlier to the fact that this process, the process of civil asset forfeiture, while it's true that there's court involvement, and it's true that people have a right to go to court, very few people can exercise that right because they don't have a lawyer. And it's true that sometimes people get sued in regular civil cases, right? They have a neighbor dispute, landlord, tenant, and sometimes they can't hire a lawyer. But this isn't just a regular civil lawsuit. This is a lawsuit in a system, as Paul said earlier, that's designed not as the state versus a person, but as the state versus some piece of property. So that means that a person who owns that property can't just show up in court and defend. They have to first go through this highly technical process of establishing their standing. You see that a lot in civil forfeiture cases. People talk about standing, whether the person whose property it is has established that it's their right to defend that property. I looked last night at every civil forfeiture case decided in the last 6 months in the Arizona Court of Appeals. Unsurprisingly, there aren't that many, even though the seizures are quite fast. But in every single one, the person whose property it was, that means they stood up to defend. They did at least enough to get through some procedural hurdles. Some of them even had a lawyer. Not all of them, but some of them. Some of them were unrepresented even at the Court of Appeals. Every single case was thrown out of the trial court on a technicality. Not once did a judge actually look at whether that person deserved to lose the money they said was theirs. In one case, which is ironically named State versus Notice, the person's name is actually Notice, that's their last name, which in an area where we care a lot about due process, right? Notice and an opportunity to be heard. I just couldn't get over that. Mr. Notice got a notice of pending forfeiture, which is the start of a forfeiture case. He got it from the AG's office. He wrote a letter and said, hey, this is my stuff. I want this back. What he didn't do was sign it under penalty of perjury. And what he didn't do was file it in court. Didn't know how. Didn't have a lawyer. And so even though the Attorney General's office knew that this gentleman wanted his property back and was asserting a claim, what it did was just move for dismissal. We just want judgment entered in our favor because you didn't do this highly technical thing about filing a copy with the seizing agency and filing a copy with the prosecutor and filing a copy in court and signing it under penalty of perjury. Now, I practice forfeiture law all the time. I could tell you how to do a claim right now. But certainly people who have $5,000, $10,000 at stake, $1,000, a car, they don't know how to do that. It doesn't matter. They're thrown out of court. He lost all his property. Court of Appeals said, yeah, too bad. The law says, the statutes say that you have to comply with these requirements, and we're not the legislature, and we have to just strictly interpret the laws. And I don't find fault with what the Court of Appeals did. They applied the law correctly. But that law needs to change. When forfeiture started, it was in the 80s. It was part of the RICO laws, and sometimes state forfeiture laws are referred to as baby RICO, state RICO, because they're modeled on the Federal Racketeer Influence and Corrupt Organizations Act. And those laws were enacted to take down organized crime, the mafia. But the people who need forfeiture reform aren't the mafia. They're regular people, people who are driving to buy a car and want to pay cash, which isn't illegal. The Seventh Circuit U.S. Court of Appeals in Chicago just 2 weeks ago had an opinion out reaffirming the fact that cash itself is not suspicious. It's what the entire economy is based on. Lots of people, especially in immigrant communities, like to deal in cash. They come from places where banks aren't reliable. But you see lots of people losing what to everyone is a lot of cash, $1,000, $1,500. But the fight costs more than that. And for the people that do stand up and fight, the prosecutors don't fight fair because the statutes allow them to fight dirty. And I'm not going to say anything that isn't public, but our complaint in the Cox case notes that Ms. Cox dropped her claim. She tried, right? She tried to file a claim, didn't have a lawyer. But when she was at the point of actually exchanging papers with the prosecutor in court, the prosecutor wrote her an email, and that email is in your packet. And it says, look, you should know that if you lose, we're going to come after you for our attorney's fees. We're going to charge you for the cost of the county attorney's prosecutor. Now, this is a case about a used truck. Let's say conservatively a prosecutor estimates the value of his time at $150 an hour, right? The appointed rate for indigent defense lawyers in federal courts about that. We'll just guess. So every time a person files a motion to which the prosecutor has to respond to, they're increasing the risk that they have to pay because it costs the prosecutor time to respond. And if they lose, they have to pay. That's just not right. And even if they get through the process, the burden's on them. That's not, no one is saying that racketeers shouldn't be divested of the proceeds of their racketeering. No one is saying that the cartel shouldn't have its proceeds taken away from them. Reforming this doesn't impact those large-scale prosecutions. There are meaningful reforms that can be enacted to help these people at the lower end of the spectrum who have property that is very valuable to them taken away, but who are clearly not involved in large-scale racketeering organizations. Mr. Chairman, you started by saying that these are the people you were concerned about. And your opening comments also talked about the fact that we don't know what's going on. We don't have a lot of data. But that's true. And data would be really helpful because as we looked into how we can seek judicial reform of the forfeiture laws, because let's face it, law enforcement is a powerful force in the legislature. There are a lot of interests, and this process has been in place for a long time. So we, a number of people sitting in this room from a number of different political perspectives, aren't simply seeking reform in the legislature. We're going to seek reform through the courts. But we need information to do that. We need to see, well, is the spending really as bad as we think? Is there really a financial incentive? And when we got through that, what we realized is it's even worse. So, Mr. Chairman, you pointed out absolutely correctly that it is impossible to figure out the nature of any individual seizure that goes into this aggregate reporting. For example, I know from anecdotal experience that most seizures are not racketeers. They're low-dollar seizures, I think below $5,000. But why don't we know that? In order to know that, you would have to file a public records request with every clerk of every superior court and get a copy of every judgment in forfeiture and then try to add them all up. And that's an extremely laborious task that no one in the public should have to do because the county attorney's offices have all the information. They filed all those papers. They should report them. If it's true that all this money comes only from large-scale organizations, maybe we don't need as much reform. I can't believe that that's true. But we should know that for sure. We shouldn't have to guess. We also can't scrutinize the spending unless a member of the public is willing to undergo an extraordinarily contentious public records request process in which organizations to whom those requests are given are not always very eager to reply. But if you stick with it, as we did, what you find out is there are a broad range of things that this money is spent on. And it's not all for crime victims and buying bulletproof vests for officers. Crime victims should have services available to them, and the state should provide those services. And every police officer should be well-equipped and should have bulletproof vests. I don't think that any member of this committee or of this House would ever vote against funding for police officers' bulletproof vests. But it's your vote. It's up to you. It's not up to the police to decide how to spend $500 million. And when it is up to the police, they spend it on some crazy stuff. In Pinal County, there is an organization called the Pinal County Justice Foundation, which was now renamed the Arizona Public Safety Foundation. In 2000, that organization is a 501c3, so it's eligible to get RICO money per the statute. It's run largely the members of the board, which you can get a little bit of information because there's some IRS reporting of nonprofits, and that's what we did. The members of the board and the incorporators, those are closely linked or employees of the sheriff's department. Sometimes it's their wives, but other family members, but they're tied to the sheriff's department tightly. In 2014, the Arizona Public Safety Foundation got $366,753 from the Pinal County Attorney's RICO Fund. That is a ton of money. They got $18,000 the year before. I have no idea what they're spending it on, neither do you. But the purpose of the organization, according to its bylaws, which are public, is to raise money for the sheriff's office and for law enforcement. But yet their largest source of money is the sheriff's office and law enforcement RICO funds. Something's going on there. I don't know what, but it's unusual. There are undoubtedly many worthy organizations that get money from RICO. But there's two problems with that. As my colleagues from the Goldwater Institute pointed out earlier, there are laws about how public money is spent in this state. There's the gift clause. There are also clauses in our Constitution and the United States Constitution about the free exercise of religion and about the establishment of religion. And if you look at the spending from the Pinal County Attorney's Office and Sheriff's Office, there are serious questions there. And again, I have information on Pinal County simply because that's who responded to our records request, and also because their own Office of Internal Audit in Pinal County published a report in 2014 that chronicles all this. You don't have to take my word for it. It's the Pinal County Office of Internal Audit that has a public report on their website listing the $366,000 donation we talked about earlier, and also listing donations to numerous churches in Pinal County, to a ward of the Mormon Church, to the Church of God, the Living Word Chapel. Those raise serious public policy and legal questions about whether it's appropriate to spend public money for religious organizations. But because it's not easy to figure out what they're spending the money on, no one knows. That raises the separation of powers question, too. The law enforcement is the armed agent of the executive branch of government.
In order to get through the rest of our speakers and start kind of wrapping up.
Absolutely, Mr. Chairman. Thank you. That's not their job. Their job is to keep us safe, and they do a great job of that, and we appreciate it. But they're not constitutionally empowered to be appropriators of $500 million. The executive branch doesn't have within it the checks and balances that the legislative branch does to ensure that when money is spent, it is spent lawfully. And it also leaves even well-meaning law enforcement officers open to the obvious moral hazard of having lots of people with whom they would like to be well thought of, people they'd like to curry favor with, for elected officials, people who they'd like to vote for them. And they have a huge slush fund of money at their disposal with very little oversight. There's lots of things that we can agree on, this broad bipartisan coalition of people can agree on for reform. We are happy to have a meaningful conversation with law enforcement about that. We'd like them to do that rather than telling us to keep trusting them and keep insulting us for the suggestion that there's any improvement that can be made. We can always do better. We thank you, Mr. Chairman, and members of the committee for helping us get started on that road. We're happy to answer any questions that you have. We're happy to be here as often as you will listen to us talk about this very important topic. Thank you.
Thank you very much. I appreciate it. Tyler Montague. Identify yourself for the record, please.
I'm Tyler Montague. I'm president of the Public Integrity Alliance. It's a membership organization based in Arizona. Our mission is to combat unconstitutional, unethical, unfair, or abusive behavior in government. We're officially a nonpartisan group. All the members of our board are Republicans. So we're often characterized as a conservative group. We are very concerned about this issue, particularly the small victims who exist in what we call the extortion zone. The extortion zone because it's just financially not worth it to try and get your property back. And we believe that this is a very abusive situation in which you lose small amounts and you have to make an investment decision on whether to get it back, and it's just not worth it. Law enforcement knows this, and as has been documented today already, uses this power to convince people not to try and seek restitution of their funds. Fueling this is the profit motive. And that's what we wanted to talk about. It's just one example. We think that that is driven by the lack of accountability in spending. And in your materials, we provided one case that's in the public domain, and this is this mailer sent out by Sheriff Babu. If you'll see that, it's got a picture, a nice picture of him in his sheriff's uniform, touting various accomplishments that he has made personally, and it says this publication is paid for by seized criminal money. Now, our organization is one of those organizations that Mr. Kabu spoke of that is trying to find out more about this. Yet 6 weeks ago, we filed a request for the records of this expenditure, who this was sent out to, how much was spent, etc. They still haven't gotten it back to us. We're going to have to sue them under a Freedom of Information Act lawsuit to get that information. Why? Well, it's speculation. Mr. Babu happens to be running for Congress right now, and this looks like a campaign mailer to us. Certainly, let's stipulate to their explanation that it's a recruiting piece of recruiting material, right? Because you see all these accomplishments, Paul Babu, so you want to go join the sheriff's office there. So let's just stipulate to that, which we don't. But let's say if that were true, is this an expenditure that the public would expect? Is this a hard law enforcement type expenditure? Is this the kind of thing that with oversight would be authorized? I don't think so. I think the answer to that's pretty unanimously no. And it's just a great example. If someone asks you for an example, this is a great example of the type of abuse of these expenditures that you can point to where there's no accountability. They're using it for their own benefit, and it fuels abuse at the front end where they're incented to seize property that isn't against racketeering or the cartels, which we all support combating those organizations. So I just wanted to call attention to that and would be happy to entertain any questions.
Well, thank you. Yeah, I've often thought about, if I had a sign up that said, a billboard that said, Sheriff Bob Thorpe incarcerated, 10,000 people last year. The only thing that would be missing is vote for Bob Thorpe. And
absolutely.
That's pretty interesting. Well, thank you very much. I appreciate your time this morning. I think I'm going to announce something that I would certainly entertain speaking with the stakeholders as far as from my office making some FOIA requests. So I think that's something that would be a way of us being able to pull together some information. So thank you. Let's see who is next. Yeah, well, we got a few more minutes. So Jenna Mole.
Good morning.
Dean, just identify yourself for the record.
Absolutely. My name is Jenna Mall. I'm the Deputy Director of the U.S. Justice Action Network and Fix Forfeiture. We're a national organization made up of 8 bipartisan partner organizations, 8 of the strongest policy organizations across the country, from the far left to the far right and everything in between. They don't agree on very much. In fact, this might be one of those few issues on which they do agree, and that's criminal justice reform and civil asset forfeiture reform. And if I may say, you haven't lived until you've seen the head of the ACLU, Anthony Romero, and the head of the Americans for Tax Reform, Grover Norquist, sitting in a room and agreeing 100% on criminal justice reform. It blows my mind every single time I see it. And civil asset forfeiture reform was one of the first policies that these 8 organizations decided that they wanted to work on together. They feel very strongly about the constitutional principles that should be involved in this policy. they do believe, and I want to make very clear that we see a very valuable purpose for asset forfeiture here in Arizona and across the country. When we're seizing assets from criminals, that is a good use of law enforcement. That is a good thing for us to be doing to keep our country safe. The problem that we run into is when it's not criminals involved, when it's private property owners who have not been charged or convicted with a crime. And so I just wanted to lay out kind of the two main goals of our organization, of our 8 partners. Number one, we seek to make sure that innocent property owners are protected and have adequate due process protections. So we seek to have a conviction prior to a forfeiture being complete in order to ensure that we are indeed taking assets from criminals rather than law-abiding citizens. Number two, and this is something that you touched on earlier, Chairman Thorpe, we seek to promote transparency in this process. Taxpayers and you as watchdogs of taxpayer dollars, you need to know how these funds are being used. You need to know what they're going for. You need to be able to evaluate the way that law enforcement is using these things. So we work on these 2 policy areas across the country. And other states have really embraced these principles for a very long time. Nebraska, California, North Carolina, Minnesota, Missouri, Vermont, you find these 2 principles already in their statutes. And it's growing. Just in the last year alone, your neighboring state, New Mexico, enacted comprehensive legislation that really embraces these principles. Montana and Nevada followed suit shortly afterwards. And actually, just this very month, Florida's legislature unanimously enacted legislation, which we expect the governor to sign, that requires proof beyond a reasonable doubt before forfeiture can be final. They require an arrest associated with the property. They dramatically expanded reporting requirements, and they actually did something I've never seen before. They actually penalize law enforcement if they don't report adequately. They withhold, and then they eventually fine them if they don't provide that information to you all as representatives of the people. And I think importantly, in Florida, law enforcement wholeheartedly supported these reforms. They worked with the stakeholders to create a good policy package that they thought would establish asset forfeiture in their state while protecting private property owners. And I think that really underscores why I'm here today and why we're seeing this issue grow and grow across the country. When you've got conservative organizations and progressive organizations working with law enforcement to put together this policy package, I think you have to kind of stand up and take notice. And to me, that's a clear sign that it's time for Arizona to be working on this policy as well. Mr. Chairman, I want to thank you for holding this hearing and having this, in my opinion, very important policy conversation. And on behalf of the largest bipartisan coalition on criminal justice reform in this country, I urge the state of Arizona to take up this policy.
Thank you very much.
Thank you.
Is Brent here? Why don't you come on up, and we're going to have to be everyone else that's going to speak, if we can, 2 minutes maybe, because we're running out of time rapidly.
Good morning, Mr. Chairman, committee members. I will be brief. I'm Brent Backus. I'm with the 10th Amendment Center. Tax supports civil asset forfeiture reform in Arizona, and we'll work with the committee, the chair, other members of the legislature, as well as the stakeholders in this room. Thank you.
All right, thank you. How about Will? Is Will here? You'll have to pronounce your last name for me. Gowan, is it, or?
Thank you, Mr.
Close?
Chair. For the record, Will Gaona with the ACLU of Arizona. And thank you all for being here, and especially to the chairman for ensuring that this issue did get a public hearing this year. I'll be fairly brief. Just want to say that the ACLU does believe the practice of civil asset forfeiture should be abandoned. We certainly support meaningful reform efforts, such as some of those that have been proposed down here already this year. I think I can speak for all the members of the coalition when I say we're always happy to continue to discuss this issue with you, meet with you, and provide you with more information, and be of assistance in any way that we can. And thank you again for the time here today and for showing up and listening on this issue.
Thank you very much. How about Ed?
Morning, Mr. Chair, members of the committee. My name is Ed Maldonado. I am an attorney. Excuse me, I'm the immediate past president of an organization called Los Abogados. We are the Arizona Hispanic Bar Association, here representing them, and proud to join this group of diverse organizations, and just want to, again, express our support for this measure. You've heard all the substantive stuff already. I just want to let this body know that we have a large contingency of criminal defense attorneys who deal with these issues on a day-to-day basis, and we've heard a lot from them how this does need some reform. Personally, I'm a rookie to this particular issue. However, I am currently involved in my very first forfeiture case with the good help of some of these people here. And just to speak briefly, 30 more seconds about that, so you can see a real-life situation of something's going on right now in the facts of that case. I have a young man who was pulled over in the West Valley heading down towards Mexico on a very popular route to Mexico, pulled over by a police officer who said he was traveling 10 miles over the speed limit. The officer was in an unmarked car. They show up with other officers. They ask him if they can search the vehicle. He doesn't know what's going on. They tell him he's speeding. He says, sure, go ahead. I have nothing to hide. They search his vehicle. They go into one of his personal bags within the vehicle, and they find $9,000 in cash. He has $338 in cash in his pocket. When they ask him about the money, he says, I'm a farmer down in Mexico. He's a United States citizen born in this country. His family isn't from Mexico. His family lives in Mexico. He went to school in Mexico. He was educated in college as a farmer. I don't know what the degree is called. But in any event, his family has farms. He runs that operation. He says, I have cash to buy products to pay some of my workers. It works better that way on the border cities there. And they don't believe that. And so what they do is they strip him of all his property. They take his truck with all his equipment. He's got, for lack of better, bee equipment because he's doing honey and all that kind of stuff. He had just bought brand new equipment. He has receipts for that equipment. He has other farming equipment. One of the reasons they say that they suspect he's into money laundering is because he's covered in John Deere regalia. His truck has John Deere stuff. He's got a John Deere hat. He's got a John Deere shirt. According to them, that's indicia of drug activity. That's news to me, having worked in the criminal defense area for now a little over a decade and as a former prosecutor. But whatever the case may be, that's what they say. That's their reasoning for doing all of this. So they take his truck, all of his cash, and they dump him literally on the side of the road in Buckeye. They drive him to a gas station, and they give him a paper. He doesn't even know what it is, assuming it's a receipt for what they took, and says, good luck to you. I then get involved. I make some phone calls because I'm curious, well, if you pulled him over for speeding, did you give him a ticket? The answer is no. After multiple phone calls, I found out there was no ticket issued. I didn't want him to miss a court date. I ordered the DR, the departmental report with all the information. They list all these things according to what they believe is to be true. I asked him a ton of questions, wondering what's going on. He says, that's my cash. They even asked him, why do you have $9,000? He says, because I travel back and forth to Mexico. I know that I can take less than $10,000 in cash and not have to declare that. I know what I'm doing. This is my business operation. He has bank records, everything you could imagine for a beautiful case to defend this. However, again, because we're dealing with $9,388 and his truck with his equipment, there's a cost risk analysis that goes on. But this man has chosen to fight this, and it's going to cost him a pretty penny to go forward with this. And we're in the middle of that litigation right now. The reason I bring this up because it is just absolutely absurd what law enforcement is capable and able to do and not have any recourse whatsoever. And so, again, that's just a little taste of one current case. I could talk to you for hours about that, and I just appreciate you hearing me out. Again, there is a great need to have this heard and to have some action taken. And again, I appreciate you all for being here, and thank you for my time, Mr. Chair.
Thank you, and for you and for everyone else that's testified or didn't have a chance to testify. Perhaps we can have some additional stakeholders meetings and discuss this further. So I truly appreciate it. Goodness, I thought I had a fairly good grasp of this topic, and from some of my notes and some of what I heard today and what I'm going to review, I have a lot more to learn about this topic as well. So with that, we all need to get up onto the floor, Oh, yes. Just real quick, because we are running late for the floor.
Thank you, Mr. Chair. I just want to thank you for bringing this issue forward. I was really excited to hear, when my staff told me that you were already working on something this summer, and, you definitely have my support going forward. And
thank you.
And for members in the audience, please consider me an ally.
Representative Larkin was one of the first members, and Representative Larkin and I are on two different political aisles, but he was one of the first people here at the legislature who came to me and said, it was supportive and told me that he was very concerned also with civil asset forfeiture issue. Madam Alston.
Well, thank you, Mr. Chairman. I just want to echo my thank you for bringing this topic forward, and I look forward to some solutions.
It's pretty pretty interesting. I think covers a huge gamut, including, people that are legal citizens coming across the border for legal purposes. What a shame that we have to deal with those problems as well. And with that, we need to get up on the floor. So thank you once again for members and for everyone in the audience. Really appreciate you taking the time today. And we are adjourned.